So today we'll be doing professional ethics prediction question 2026, and this is very deliberate because I have exhausted questions from the course outline. Remember, this is set B and we did set A and uploaded the same. So, and in answering, there are some rules that you ought to stick to because many students usually breach these rules from the word go. So, for instance, all questions are problem questions, and in each answer that you'll be giving, you need to identify the ethical concern, state the applicable legal rule or test, apply it to the fact, and give the practical advice to that individual. Then you are highly encouraged to support your answers with the Constitution of Kenya, the Advocates Act, the Evidence Act, the LSK Act, subsidiary legislation, SOPEC, and relevant judicial authority. And when relying on a judicial decision, you will be allowed to state briefly its material facts, issue, and relevant holding so that the examiner sees that you have duly read that decision. Allow me to mute you. There is a background noise. Maybe Madam Jane? Oh yes, I've muted you. Yes, kulikuwa na background noise huwa interfere na recording. So, the other thing that I'm also stressing is that where you're supposed to draft, you use the correct form, professional language, and appropriate prayers or clauses. And you should assume all events are occurring in Kenya and use the statutory provisions and subsidiary legislation applicable as those enforced during the 2026-2027 academic year course outline. So the first question before you carries 40 marks deliberately. And this was a combination of various competing duties of an advocate. And I'll read out the question, then expect to hear your, maybe the concepts that you can be able to deduce from such a fact. So Maya Advocates holds a valid practicing certificate and is a partner at Integrity Legal LLP. Kibo Holdings Limited instructs her to challenge the compulsory acquisition of its land. Kibo's managing director, Malik, privately informs Maya that the company bought the land using money concealed through several shell companies. Malik instructs Maya not to disclose the source of funds. Malik gives Maya a draft affidavit stating that Kibo purchased the land using legitimate trading income. Maya knows that the statement to be false. Malik tells her that an advocate's duty is to advance the client's interest and threatens to instruct another firm unless she files it. Malik also asks Maya to receive 50 million into the firm's client account, hold it for 2 weeks, and then transfer it in 5 installments to an overseas consultancy. He refuses to disclose the consultancy's beneficial owner. He claims that the transaction is protected by the advocate-client privilege. Maya upholds the pleadings, uploads the pleadings and evidence to a free public artificial intelligence platform. The platform generates submissions containing 6 authorities. 2 authorities do not exist and another does not support the stated proposition. Maya files the submissions without verifying them. These are a new area. After the court questions the citations, Maya posts online that the judge does not understand modern technology and is protecting land thieves. Our client will certainly win on appeal. She attaches a screenshot of Malik's email discussing litigation strategy. Maya also agrees to pay a popular blogger 10% of every fee received from clients referred by the blogger. Advise Maya and the Integrity Legal LLP on the ethical implications of these facts. In your answer, address her duty to the court, confidentiality and privilege, anti-money laundering obligations, use of artificial intelligence, social media conduct and fee sharing, and draft a short letter declining Malik's unlawful instructions. So if you were in a position to hear out that kind of a question, I've touched across various competing duties of an advocate, even in the current era of the use of AI, one of the most predictable area that we are predicting in 2026. So it is an open question. You just tell us, what have you heard and what is the backing that you can support, so that we greatly appreciate your attempt in what you have had. Thank you. So members, the floor is yours. You can try, even 1 point will be greatly appreciated. Okay, because you said Mr. Brian and Mr. Martin, we will be waiting for your confirmations. Allow me now to go ex parte, unless Madam Jane you have a clarification or a point. I will go ex parte and clarify what the examiner will be expecting to hear from you. Is that appropriate, Madam Jane?
Yeah.
Okay, so thank you. So, you have heard all those stories. So, one thing that I'll say is that Maya's fundamental error is to treat loyalty to her client as an unrestricted obligation. An advocate owes several concurrent duties. We have loyalty, confidentiality, competence, and diligence to the client, honesty, candor, and fidelity to due process to the court, fairness to other practitioners, and integrity to the public and administration of justice. Where a client demands deception or illegality, the advocate's duty to the court and the law will always prevail. That is the marking point number one, that you never allow the advocate's duty to the client to prevail beyond the court. The statutory provisions is that Section 55 and 56 of the Advocates Act recognize the advocate's status and responsibility as an officer of the court and permit punishment for professional misconduct in the face of the court. And SOPEC 8 requires fidelity to the law and due process, while SOPEC 12 requires honesty and integrity. So that is how you marry between the Advocates Act and the SOPEC rules. So Section 55 and 56, you are an officer of the court. Now, which SOPEC allows you to confirm with the duty to the court? And it is Section SOPEC 8 and SOPEC 12. And SOPEC 8, you owe fidelity to the law and due process, and SOPEC 12 will require you to practice with honesty and integrity. So the advocate's independence means that professional judgment cannot be surrendered to a client, employer, or fee-paying pressure. So you are independent. And the landmark decisions to support such kind of answers, you will say the case of Rondell versus Sosley, 1969, where a barrister was sued by a former client over the conduct of a criminal defense. The issue was that the nature of counsel's professional duties and the then existing immunity from suit. And the House of Lords emphasized that the counsel is not merely the client's mouthpiece and owes an overriding duty to the court and the administration of justice. Although the historical immunity aspect must be treated cautiously in modern Kenyan law, the case remains relevant to the proposition that an advocate may not mislead the court merely because a client demands it. So the case of Rondell versus Sosley will also support the argument being advanced by SOPEC 8, 12, and Section 55 and 56. Similarly, in the case of Charles Koigi Wamwere and two others versus Republic 1992, the court dealt with the limits of advocacy in criminal proceedings. Its relevance lies in recognizing that forceful representation must remain within lawful and professional bounds, and zealous advocacy does not authorize abuse, obstruction, or even deception. So one mistake that you'll ever do is to assume that in the professional ethics unit, you will not be required to cite decisions. You will be misconceived because some decisions like Omtele carries a significant principle that if an examiner sees you are omitting in your answer, automatically he knows you don't know what you're talking about. So be keen on professional ethics. So the rest are theoretical aspects of how you could argue out your case in an ethical manner, and I'll brush it briefly. Maya must therefore refuse to prepare, commission, or file the proposed affidavit. An affidavit is evidence on oath, and filing it with knowledge that its central statement is false would mislead the court, assist perjury, or fraud and abuse the judicial process. she should explain to Malik that the company may advance only truthful evidence and legally supportable submissions. She should invite him to correct the affidavit and provide genuine supporting material. If he insists upon the false account, Maya should cease acting in accordance with the applicable procedural rules and in application to the cab rank rule. If Maya has already filed false evidence, mere withdrawal may not discharge her duties. She should advise the client to correct the record. If the client refuses, she should consider the remedial steps permitted or required by law, confidentiality rules, and even court procedures. She must not compound the deception and repeat the false statement or rely on it in argument. Confidentiality and advocate-client privilege must be distinguished. Confidentiality is the broader professional duty not to disclose or misuse information acquired through the representation, while privilege is principally an evidential protection applying to specified confidential professional communications. Article 31 of the Constitution supplies a wider privacy context, while Section 134 to 137 of the Evidence Act govern professional communications. Since Section 134(1) of the Evidence Act provides that without the client's express consent, an advocate shall not disclose communications made in the cause and for the purpose of professional employment, disclose the contents or condition of documents encountered in that employment, or disclose advice given to the client. And under Section 134(2), that protection continues after the professional employment ends, and the provision expressly excludes communications made in furtherance of an illegal purpose and facts observed by the advocate showing that a crime or fraud was committed after the employment began. So those are the exact marking points that the examiner will be expected to hear, that you are even appreciating Section 134(1) and Section 134(2), and the exception that confidentiality will even survive your employment or advocate-client relationship. So the privilege test asks whether legal advice or representation was sought from an advocate acting professionally, whether the communication was made for that purpose, whether confidentiality was intended and preserved, and whether an exception or waiver applies. And privilege belongs primarily to the client rather than the advocate. In the case of Tom Ojienda, trading as Tom Ojienda and Associates Advocates versus EACC 2016, investigators sought access to an advocate's accounts and material in the course of an anti-corruption investigation. The dispute concerned the extent of advocate-client privilege, confidentiality, and investigatory powers, and the court recognized the importance of privilege but rejected the proposition that every transaction or document involving an advocate is automatically privileged. So the decision is relevant because privilege protects qualifying professional communications, not the use of an advocate or client account as an automatic barrier against lawful investigation. This is relevant because we have been told there is an account that is going to be receiving 50 million Kenyan shillings. So it is not to say that the advocate-client confidentiality or privilege communication is absolute. No, we have been told in Tom Ojienda, trading as Tom Ojienda and Associates Advocates versus EACC, that will not extend beyond a certain limit. So Malik's admission concerning past wrongdoing may remain confidential. So know how to separate when you know of a certain offense between you and a client. So if it was in past, that will remain confidential and may attract privilege if made genuinely to obtain legal advice about existing legal consequences. A client is entitled to seek advice concerning past misconduct, and the position differs whether the communication seeks an advocate's assistance in carrying out, concealing, or advancing future illegality. The proposed use of Maya's client account to receive, structure, and transmit suspicious funds may fall within the legal purpose exception, and the facts of the financial transaction, the source of the money, destination of the money, beneficial ownership, and movement of the money are not necessarily privileged legal advice merely because an advocate is involved. So the proposed 50 million transaction presents multiple anti-money laundering warning signs. These include the use of shell companies, a transaction inadequately connected to the compulsory acquisition case. Take note of Section 4A of the Law of Section 4A of the Law Society of Kenya Act and the applicable anti-money laundering legislation of 2025, because if you read Section 19 of the POCAMLA Act, okay, proceeds of money laundering, it tells you that the court can make an order. The court has an inherent power to make an order for the advocate to bring various information between him and a client before it, if there is a challenge or investigation going on. But we are being told it will still respect the extent that the advocate-client relationship is still protected. So even if it is making an order, it will still respect the boundaries of the advocate-client relationship. So being keen on the use of POCAMLA Act, we have seen this year many advocates being cited for bribery allegations, many magistrates being apprehended for corruption charges. So be keen when you're being told that a certain magistrate has made an order against an advocate-client relationship. So another thing that is also arising from this situation is Maya's use of artificial intelligence that will be posed before you by the examiner. And one thing that I want you to appreciate on artificial intelligence, it is raising competency, confidentiality, diligence, candor, and supervision concerns. And competence in this sense that we have seen decisions rendering some documents incompetent. So that is what is forming a prediction angle. You're supposed to be competent and diligent in your work as an advocate. Confidentiality in the sense that many AI program softwares are unregulated in Kenya. We are currently having a bill. In fact, the examiner can even tell you that Kenya is yet to implement a law to regulate that sector. So if we have a bill, all the information that you feed in this AI and you tag along your law firm, the person sitting behind the operation desk, they can't be in a position to form a pattern of all of your client details that is going around in your law firm. So there is confidentiality risk also coming out in the use of AI. We have diligence, candor. Okay, so SOPEC 3 requires competence and diligence in client care. So AI is a likelihood to be a likelihood area to conflict with competence and diligence. And SOPEC 7 protects confidentiality. SOPEC 8 and 12 will require candor, fidelity to law, and integrity. Okay, so technology does not transfer professional responsibility from the advocate to the software provider. So those are the SOPEC rules that I want you to start having at the back of your mind when the issues of AI will be tested. Competence and diligence, SOPEC 3. SOPEC 7, protection of confidentiality. SOPEC 8 and 12, candor, fidelity to the law, and even integrity. Okay, so we analyzed the SOPEC rules from the first rule all the way to the 12th rule. We were able to discern various rationales that the examiners usually ask students to explain, and we even analyzed the tests. And the examiner will be interested. Do you know the test of a competent and diligent advocate? Okay, so I will formulate questions on various tests so that you can measure one test against one decision, against another decision, then we settle to the Supreme Court decision that settled a certain test for the law practitioners, for the legal practitioners. Let me mute my phone to avoid distractions. So, the verification test, okay, I don't want to read theoretical aspects. Another issue arising is the use of social media. Earlier this year, we were told of various advocates misusing the social media, some were dancing. Those are current affairs. So her social media post also breaches professional standards. SOPEC 10 allows responsible social media participation, but does not permit disclosure of confidential information. Unsupported attacks on judicial officers, reckless allegations or claims that undermine confidence in justice. Advocates enjoy freedom of expression under Article 33, but Article 33 does not protect expression outside constitutional limits, and professional obligations legitimately regulate how an advocate comments on ongoing proceedings and client affairs. So that is also an important feature arising from those facts. We have also seen an issue to do with blogger activity. So there is a blogger arrangement that raises improper solicitation, touting, and prohibited profit sharing. Under the advocate's practice rules, an advocate should not share professional profits with an unqualified person or use paid agents to procure work. The Advocates Marketing and Advertising Rules of 2014 permit regulated factual advertising but do not legitimize misleading claims, guarantees, aggressive solicitation or referral commissions to non-advocates, and the 10% payment is not an ordinary advertising fee fixed independently of legal fees. It is a direct participation in professional revenue and should be terminated. So the question also involved drafting of a certain letter, and this letter, I will not delve into the details of it because it is not of paramount importance like the way we are extracting out various tests from a question. Question 2, I deliberately lifted it from conflict of interest and advocate appearing as witnesses. In 2023, this one at least it is shorter and it will now invoke your thoughts to see whether you know the landmark tests of conflict of interest. So in 2023, CIFA advocates jointly represented Lake Bank and Jambo Estates in preparing and registering 300 million loan and charge. The firm received Jambo's board minutes, internal valuations, and confidential cash flow forecasts. In 2027, Lake Bank instructs CIFA advocates to release the security after Jambo defaults. Jambo objects, alleging that the charge was executed without board authority and that CIFA's former partner assured it that the bank will not enforce the security for 5 years. The former partner is likely to be called as a witness. Lake Bank argues that both parties consented to the original joint representation and that a different department of CIFA advocates can conduct the litigation behind an information barrier. Advise the parties on ethical concerns, the legal test for disqualification, consent, confidential information, information barriers, and the advocate appearing as a witness dilemma. So that we understand and appreciate the question, I revisit it in an informal manner. We are told in 2023 there is a CIFA advocate who jointly represented two clients. One was Lake Bank and the other was Jambo Estate. And it particularly prepared and registered a 300 million loan and charge. And the firm even received Jambo's board minutes, internal valuation, and confidential cash flow forecasts. In 2027, Lake Bank now, one of the former client, instructs the same advocate to realize the security after Jambo defaults. And Jambo objects, alleging that the charge was executed without board authority and that CIFA's former partner assured it that the bank will not enforce the security for 5 years. So the former partner is likely to be called as a witness. Now, Lake Bank argues that both parties consented to the original joint representation and that a different department of CIFA advocates can conduct the litigation behind an information barrier. So before you, what do you know? What exactly do you know that the examiner is looking for in a conflict of interest where an advocate is likely to appear as a witness? And believe you me, these are facts from a landmark decision appearing in the cause outline. That is rider number 1. Rider number 2 is that many students will read these units in a way that they are brushing up, because we are in third term. We are rushing to finish up with the curriculum, but we don't know the loopholes that can form a question. So I'm posing before you, what exactly do you know about conflict of interest and advocate appearing as witnesses? What are the landmark decisions that the examiner should see in your answer? Any member? Because I don't want to appear like I'm school feeding. I just want you to exercise exactly what you know, exactly what you could have written. This is the point where you will now start going away from the statistics that will fail professional ethics. These are the tests that determine will you be under the 30% minority to pass professional ethics, or you will be in the majority of students who only approach this question with a general knowledge. Any member, you just say what you know. Assume this question imekuja mandatory in November 2026 paper. What are the legal tests for disqualification? What is a Chinese wall? Because Lake Bank is trying to say, look, there is a doctrine known as the Chinese wall. And if there is an information barrier, CIFA advocates can conduct. What are your thoughts? What can you see? What is the name of this landmark decision that is displayed before you? Did you read the decisions appearing in the professional course outline? Yes?
Victor, I'll give it a try. Is it the Kingulan House versus Kaplan and Stratton?
Good.
Yeah, where the court held that you should not represent both parties if it will be prejudicial to one of the parties. And the court continued, or rather proceeded to say that regardless of the fact that was it Kaplan had obtained consent from or rather the other party was aware that Kaplan would represent now the other party in case of a dispute. The court still held that it amounted to presence of conflict of interest because Kaplan already knew information about now the other party that was challenging Kaplan representing the adverse party. But now in that case, there were some decisions where the court was looking at other jurisdictions where the courts now in the other jurisdictions were talking about the Chinese wall and everything, where they were saying that if there is a barrier, for instance, in, let's say, big law firms where they have various departments, and one department represents a client and the other department represents another client who are now in conflict with this other client, then the doctrine of the Chinese wall will come into play in that the firm will be allowed to represent both parties because they have this assertion or rather belief that these two departments don't have information of the adverse parties. So in that particular case, they can represent both parties because they don't have information. Let's say Department A doesn't have information of this other client being represented by Department B and vice versa. I don't, that's what I can remember from that particular case.
Thank you, Kista. Thank you, Kista. You are well read. If you have managed to read that decision in its entirety, then you appreciate what we call the conflict of interest. And do you know any tests that will inform the court to say, look, you have met the test that you are looking for you to claim there is a conflict of interest in this scenario? What are the tests?
I am not conversant with the tests.
Okay, so let us read the answers. I appreciate when a person tries out one of the segments, then we rush to the answers and see what the examiner will be expecting. So the dispute raises duties of loyalty, confidentiality, independence, and fairness to the administration of justice. Rule 8 of the Advocates Practice Rules deal with an advocate appearing in a matter in which the advocate may be required as a witness. So that is a legal test, not a legal test, sorry, a legal provision ya kwanza to make your answer not to be dry. Rule 8 of the Advocate Practice Rules deals with an advocate appearing in a matter in which the advocate may be required as a witness. And SOPEX 6 governs conflict of interest, while SOPEX 7 protects confidentiality and privilege. So if your answer lacks such answers, automatically you are giving a theory. So a former client conflict does not produce automatic disqualification in every case. And the court must balance the former client's right to confidentiality and fair proceedings against the current client's right to counsel of choice. So, 1. Already ushaanza kuona some elements coming out clearly. It is not an automatic disqualification because there is a former client conflict. No. The court will do a beam balance test. They will test the former client right to confidentiality and fair proceedings against the current client's right to counsel of choice. That is 1. The disqualification test asks whether an advocate-client relationship existed, whether the earlier and present matters are identical, related, or substantially connected, and whether the advocate received confidential information relevant to the present dispute, and whether there is a real risk that the information may be used or disclosed, and whether continued representation creates real prejudice or threatens the integrity of the proceedings. The concern must be real and not merely fanciful or tactical. Hii paragraph iko heavily loaded because we have situations where the examiner will tell you, kindly give the various issues arising from the factual matrix. And the issues arising where there is a conflict of interest, we have, did we have an advocate-client relationship? Are these matters identical or substantially connected? Did this advocate receive confidential information that is relevant to the present dispute? Is there a real risk that the information may be used or disclosed? Is continued representation creating a real prejudice or threatening the integrity of these proceedings? And this concern, is it real or is it merely fanciful or tactical? In King Woolen Mills Limited, formerly Manchester Outfitters Suiting Divisions Limited, and another versus Kaplan and Stratton Advocates, 1993, the firm had acted in preparing securities or transactions and was later instructed in litigation in which the propriety and effect of those transactions were contested. The issue was whether possession of confidential information from the earlier relationship created a disabling conflict, and the Court of Appeal restrained the firm, emphasizing that an advocate who has obtained confidential information from a client should not later act against that client in a substantially connected matter where the information may be relevant. The case is directly relevant because CIFA prepared the charge now under challenge and received Jambo's sensitive internal documents. That is exactly how the examiner will be expecting to hear from you. Remember, I told you the preceding paragraph is heavily loaded. The examiner must see the test. Remember, we are told allegedly that professional ethics papers and some other units are marked, are usually allocated to senior advocates. So there is seniority. So LPM can be granted to, if you are new in the marking bench, but there are sensitive units like professional ethics that are granted to senior advocates. So they know this test by the virtue of practice. Okay, so kama hiyo ni ukweli, let us be keen on how we answer. It is not merely to say King Woolen Mills that only remember. It is not about remembering a decision. It is about, do you know this decision? Do you know its rationale? Can you connect the rationale with the factual matrix and the test that you know, and even the law that you know? That is professional ethics. Okay? So, in King Woolen Mills, have you had the balancing test that is eminent, kwanza? Is there confidential information from the earlier relationship? Okay? Then, is there a likelihood that this information is relevant in this current decision? Okay? Then, is there any prejudice that can be occasioned to one of the parties that was a client? And this is how we linked it to the factual matrix. This case is directly relevant because CIFA prepared the charge now under challenge and even received Jambo's sensitive internal documents. There is another decision that the examiner is also expecting to hear from you. In Uhuru Highway Development Limited and 3 others versus the CBK of Kenya and 4 others 203, an advocate's previous involvement and access to confidential information were invoked to seek disqualification in later proceedings. The central issue was the proper threshold for preventing counsel from acting against a former client. And the Court of Appeal held that the applicant must demonstrate real mischief and real prejudice arising from the possibility of confidential information being used rather than rely on a bare allegation of previous representation. The decision supplies the real prejudice test. So believe you me, King Woolen Mills is a separate authority from Uhuru Highway Development because Uhuru Highway Development case is coming to establish a real prejudice test. So that is how we mark the test applicable in the factual matrix. Read another decision. In Delphis Bank Limited versus Chan, Sain, Chath, and 6 others 205. All these decisions are provided in the cause list. A party sought the disqualification of counsel based on earlier professional involvement. The Court of Appeal stressed that disqualification should not be ordered lightly and must be founded on a genuine risk to confidential information or the fairness of trial. And the case is relevant because it prevents conflict objections from being used simply to remove an opponent's chosen advocate. Remember what I told you? There is a balance between the right to counsel, choice of counsel, and the right to prejudice. So Delphis Bank Limited exercised that it should not be light or easily acquired because you are limiting the choice of an advocate. So the present matter is substantially connected to the earlier retainer. CIFA prepared and registered the very charge now under attack, and questions of corporate authority, execution, assurances, and enforcement arise from that transaction. Jambo's board minutes, valuation, and cash flow forecast may assist the bank in attacking Jambo's defense or negotiating settlements. There is therefore more than a speculative risk. So you're even telling the examiner, look, because I know the kind of documents that exchanged hands, there is more than a speculative risk. I did not cram this unit. I know what you're looking for, and in this factual matrix, it is an exception to the rule. So consent to the joint transaction in 2023 did not necessarily amount to informed consent to future hostile litigation. Valid consent requires adequate disclosure of the nature and foreseeable consequences of the conflict, independent and voluntary decision making by persons with authority, and a conflict that is legally capable of being waived. Some conflicts cannot reasonably be cured because effective representation will be materially impaired or because the administration of justice will be compromised. An information barrier is relevant but not decisive. The court should consider whether it existed before the conflict arose, whether electronic and physical access is restricted, whether screened persons are prohibited from discussing the matter, whether supervision and remuneration are separate, whether undertakings and audits exist, and whether confidential information had already circulated. A barrier constructed only after the dispute emerged is less persuasive. This point is very important because Kista told us about the Chinese wall arrangement. So the examiner can tell you to advise on how a Chinese wall arrangement can be utilized. So a Chinese wall arrangement can be utilized as it was discussed in Kaplan versus Stratton Advocates, and it can be seen with the following points. Did electronic and physical access restriction applicable? Was it applicable? Was there any screening of people from prohibition? Okay, let me read it as it is. Whether screened persons are prohibited from discussing the matter, whether supervision and remuneration are separate, whether undertakings and audits exist, and whether confidential information had already circulated. So that can defeat the purpose of a Chinese wall arrangement. So the advocate witness rule creates an independent difficulty. CIFA's former partner may have to testify about the alleged assurance and circumstances surrounding execution. The test is whether the testimony is necessary, material, and contested, rather than merely formal or cumulative. An advocate should not combine the roles of witness and counsel because that may confuse evidence with advocacy, impair independence, and place the firm in position of defending its own conduct. So remember what I told you? We started with the advocate practice rule of, when we said rule 8 is the one that is dealing with the advocate appearing in a matter in which the advocate is potentially to be called as a witness. Now, here point in the sink. With those kind of decisions, it may sink. Of late, we have seen demonstrations from advocates saying some judges are making it practically impossible for EACC officers to investigate them. And they even conducted Wali block roads in demonstrations challenging the impunity of the judiciary. Usidhani CLE hayuni news. CLE iko aware, and that is raising an important question on judicial bias and recusal. So let us read the factual matrix, then we test ourselves. Do you know the exact test for judicial bias and recusal? Duty to sit when it conflicts with the duty to recuse yourself. Now, a constitutional petition challenging a county procurement award is listed before Justice K. 5 years earlier, Justice K was a partner in a firm that advised the successful bidder on an unrelated employment dispute. And the judge's spouse currently owns a small number of publicly traded shares in the bidder's parent company. During an interlocutory hearing, Justice K states, "Your client is one of those activists who oppose every development project." Justice K later attends a public dinner at which opposing counsel receives an award, and a photograph of them conversing is circulated online. The petitioner instructs his advocate to apply for recusal and publicly accuse the judge of corruption. Advise the advocate on the test for recusal, the relevant and irrelevant considerations, the distinction between adverse views and bias, and the limited quorum exception. Draft the principal prayers and grounds of a recusal motion. So this is where the examiner is also testing to see, can you draft an application seeking for recusal? Who told you that professional ethics is just about mastering limitations and exceptions and even tests? You can also be put on your feet to draft. So can you draft? Now, do you know the test for recusal? Have you read the Bangalore Principles? Have you read the ODPP conduct rules? Because the examiner can tell you that today a person X is from the office of the ODPP. Have you read the conduct that govern the ODPP's office? For instance, when matters to do with recusal. How well read are you in judicial bias and recusal applications? So in answering this question, I don't want you to answer in a way that ni kama una cram hizi paragraphs. No. Just extract the identifiers. Let me repeat the question so that you see exactly what I want you to see. So there is a constitutional petition that is challenging a county procurement award that is listed before Justice K. But 5 years earlier, we are told that this honorable judge was a partner in a law firm that advised the successful bidder on an unrelated employment dispute. So the judge's spouse currently owns a small number of publicly traded shares in the bidder's parent company. So during an interlocutory hearing, Justice K states, your client is one of those activists who oppose every development project. And Justice K later attends a public dinner. Have you read the judge's code of conduct on public appearances or public harambes? When they receive a gift, what should they do? And a photograph of them canvassing is circulated online. We even saw in the JSC interviews where a person lost a certain seat because of judicial bias and recusal. Who told you that CLE did not watch those news? So, from your own view, do you know the law applicable for recusal? Do you know the test for recusal? Do you know the irrelevant considerations that you can write in your examination? Do you know how to draft an application for recusal? And do you really know about matters to do with judicial code of conduct? So the floor is yours. You try out, then you'll see the marking scheme. Any member? What are the tests for recusal? Ukiangalia the pattern of how I've intended to predict these questions, if you appeared in set A, you realize set A questions were easy. Set B questions zimeingia ndani. Set C questions zinaongeza complexity. So it will be of beneficial interest to you if you attend many prediction papers, because tunaenda tukidig deeper. The matrix is also informed with how CLE in a test. Remember, ndio tufike hapa, we have done several papers. So there is a pattern ishaanza kuform at the back of our heads. Okay? So by the time tuna project such kind of a question, probability is so high that if the examiner is to retrieve a question on judicial bias and recusal, he will test one of the tests outlined before you, because part C predictions will be a combination of judicial bias situation now as a typical CLE paper. Kuna judicial bias, kuna conflict arising, okay, so itakuwa a blend. Lakini part C, okay, prediction C haitakuwa so complex to make you lose the test that the examiner want, because by the time we are reaching the last prediction, I will be in a position, every sentence in that question will be a marking point. It will be that diluted, because I believe the moment tunaenda tukiingia hivi tunajua basics, pia we should prepare our minds for any twist of events, and we'll appreciate to read every sentence in a question, underlining, seeing the examiner's footsteps. So be keen on prediction questions zenye tutakuwa tunaleta before you. So hapa already naanza ku establish one thing. Students at this point, they had a weakness in appreciating landmark cases. They had a weakness in appreciating the various tests. Even if a student remembered that case, they never knew the relevance, the rationale that was advanced by that case. Another weakness that is also eminent is watu bado hawajashika SOPEC rules. Hawajashika SOPEC 6, hawajashika 7, hawajashika 8, nini bado, lakini usikuwe na mbio, tutazishika. So what can you say for question number 3? Ni mtihani sasa, mandatory question. Okay, so this question, many students could have failed. The answer: judicial recusal protects the constitutional right to a fair hearing and public confidence in impartial justice. Article 51 and 160 of the Constitution are central. Article 51 guarantees a fair and public hearing before an independent and impartial court or tribunal, while Article 160 protects judicial independence. Where did we start from? We started from the Constitution of Kenya. Because Article 51 guarantees a fair and public hearing before an independent and impartial court or tribunal, while Article 160 protects judicial independence. And the Judicial Service Code of Conduct and Ethics Regulations of 2020 and the Bangalore Principles also require independence, impartiality, integrity, propriety, and equality. Now, what is the test? You have already identified the legal provisions. You are very good. 1 mark is yours. Now, what is the test? The objective test is whether a fair-minded and informed observer, having considered the relevant fact, would reasonably apprehend that the judicial officer may not bring an impartial mind to the determination. Stop there. A student, Amanda Kandika, one of the tests for judicial recusal is a fair-minded observer. Without informed their decisions, to tell you, a fair-minded observer without being informed is null and void. So sioni ni kama tuna cram conjunctiveness. It is decisions zimetufanya tukaweka hiyo kitu hapo. The objective test is whether a fair-minded, and he must not only be fair-minded but informed observer, having considered the relevant facts. You cannot consider relevant facts if you are not informed. Will reasonably apprehend that the JO may not bring an impartial mind to the determination. The applicant's subjective suspicion is insufficient, while the judge's personal belief in their own impartiality is not conclusive. There is a presumption of judicial impartiality, rebuttable by cogent evidence. Good. Do you have a case law to support your answer? In Rev. Jackson Kipkemboi Koskei and 7 others versus Rev. Samuel Mureithi Njogo and 4 others 207, the judicial officer's conduct and comments were relied upon as evidence of bias. The issue was whether the circumstances established a reasonable apprehension that justice will not be administered impartially. The Court of Appeal emphasized the objective appearance of impartiality and cautioned that judicial authority should not be used to shield personal sensitivity or punish legitimate applications. The case is relevant because a respectful, fact-based recusal request must be distinguished from contempt or personal attack. The reasoned authority identified in the cause outline was Gachagua and 5 others versus Maingi and 8 others, 2025. This authority was inserted deliberately by the reviewers of the cause outline. Okay? Because this decision should be consulted for its precise current formulation of the recusal test. Its relevance is the Court of Appeal's treatment of objective apprehension, disclosure, judicial impartiality, and the need to avoid both actual injustice and tactical judge shopping. A candidate should not rely on the citation without reading the full official judgment. Okay? So that is to tell you, kindly read the ruling that Gachagua applied to the Court of Appeal, and it was delivered by the Court of Appeal, and it was in relation to recusal. Judge's case, former firm and related employment, work for the bidder 5 years earlier may be too remote, particularly if the judge did not personally handle the matter, received no information relevant to the procurement dispute, and retained no continuing relationship. It is a fact requiring disclosure and examination, but not necessarily recusal. So you will still find students who may chukua your point that because the judge's case, former law firm acted on a bidder 5 years earlier, na run away with it. So this process shareholding is more significant because it may create a financial interest. The relevant questions are whether the interest is direct or indirect, what is its value, whether the litigation could materially affect it, and whether it is trivial or substantial. A small diversified shareholding may not automatically disqualify the judge, but disclosure allows parties to assess the risk. So the statement about activists presents the strongest ground. So what are we doing? We are analyzing the bad facts from the good facts. So adverse comments, robust questioning, and unfavorable rulings are not by themselves evidence of bias. Judges must form preliminary legal views and test counsel's case. However, language suggesting that a litigant belongs to a disfavored class and habitually obstructs development may indicate prejudgment of motives rather than evaluation of evidence. And context and the whole record are important. Now, what about public dinner? The public dinner photograph is weak standing alone. Judges and advocates inevitably meet at public professional events. The fair-minded observer is informed about ordinary professional interaction and will not infer corruption from a conversation at an open event without additional evidence. The advocate must reject the instruction to accuse the judge publicly of corruption. There is no evidential foundation to that. A recusal motion should be measured, respectful, and confined to verifiable facts. Unsupported allegations may constitute misconduct, contempt, defamation, and an attempt to intimidate the court. The rule of necessity or limited quorum exception recognizes that recusal should not disable a constitutionally constituted court where no alternative forum or quorum exists. It applies exceptionally and not for convenience. The court should disclose the difficulty here the parties and determine whether participation is strictly necessary to avoid a failure of justice. That is where you will apply the rule of necessity or the doctrine of the doctrine to sit or the duty to sit vis-a-vis the rule to recuse yourself. Okay, so it is exceptional and not for convenience, and the court should even disclose that difficulty. How do you draft a recusal application? You'll approach court using a notice of motion. Basically, this is just to tell you the language that you will use. So the petitioner shall apply for orders that The Honorable Justice K recuse himself or herself from further conduct of this petition. The file be placed before the presiding judge for allocation to another judge and cost being the cause. The application is founded on the following grounds. Sasa hapa ndio examiner anaona, do you really know the grounds for recusal? During the proceedings of this date, the court made the statement reproduced in paragraph X of the supporting affidavit concerning the petitioner's status and motives. The Honorable Judge has a disclosed or apparent prior professional connection with the successful bidder and the judge's spouse holds a financial interest in its parent company. Considered cumulatively and objectively, those circumstances create a reasonable apprehension of apparent bias in the mind of a fair-minded and informed observer. The application does not allege corruption or actual impropriety, but seeks to preserve public confidence in the impartial administration of justice, and it is in the interest of justice that the petition be heard by a differently constituted court. The affidavit should contain facts, documents, and accurate quotations. It should not contain insulting argument or unverified internet allegations. So due to time, we'll finish up on confidential. Let me select one juu hii inakaa tumeguza kidogo. Let me choose one where wachana professional undertakings, everyone hiyo hata we had a heated debate over the same. People know that one, but see, we are not ignoring. I'm looking for something yenye itakushika off guard because it is one of the areas that CLE must ask. Let me confirm kama niyo client money and fiduciary duty. Advertising hapana, hiyo mtaflow nayo. Advertising, kila mtu alishika advertising rules. Unqualified persons hapana, goja. Contempt of court, hii ni landmark. Hii imeappear severally contempt. Advocate disciplinary process, people wanna confuse between ACC, ADT. Do you know how to draft a complaint? Ethics, the prosecution, watu wengine wajui prosecution, wanajua tu public, in-house counsel, they don't know about prosecutions. Ethics from their code of conduct. Pro bono, goja, siku ingine. Law firm ownership, good. Chani confirm kabisa ni hiyo ndo natafuta. Social media hapana, siyo. See ethical decision making, this one. Cost, taxation and fee disputes. This one, even in the April series, it featured. They know students don't know about taxations and fee disputes. So this is the last question tutapitia, then we'll have the second bit of this kesho tu jioni. But in the morning tutamalizia, what did you start? We are doing commercial transaction. Now, Rafiki Advocates files a 2 billion claim for a public corporation. The suit is struck out before trial because the plaintiff discloses no reasonable cause of action. Rafiki presents an advocate-client bill calculating instruction fees solely on the 2 billion pleaded amount. The client argues that the amount was speculative and no judgment or settlement established its value. The bill also includes 5 million described as research, travel, and miscellaneous disbursements without receipts. The taxing officer substantially reduces the instruction fee. Rafiki files an ordinary appeal 45 days later without first seeking reasons or using the reference procedure. Advice on the rationale and principles of taxation, determination of subject matter value, disbursement, interest, challenge to taxation and enforcement of a certificate of cost. Automatically a gray area because even if you are reading notes, this is a bit technical. Now, what is the rationale and principles of taxation that you can try to tell us? What are the loopholes that CLE is usually testing in questions to do on cost, taxation, and fee disputes? What are the murky areas that the examiner is looking for? What generally do you know about about taxations in terms of professional ethics angle. Any member? Okay, due to time, I will summarize this one because nimeuliza deliberately because I know it is one of the area that challenges students. So, the examiner will be expecting to hear the following. Taxation reconciles an advocate's right to fair remuneration with the client's right to protection against excessive charges and public interest in access to justice. The Advocates Act and the Advocates Remuneration Order regulate the process. Do you know the landmark case? Hii kesi usiwahi kosa kumention for questions in relation to taxation because it is a landmark case. Premchand Raychard Limited versus Quarry Services of East Africa Limited. The court dealt with the appropriate level of party and party cost. It is number 3 in the cause outline on such topics. So in this case, the court dealt with the appropriate level of party and party cost. The issue was how a taxing officer should balance compensation, consistency, and public access. And the court held that cost should not be so high as to restrict access to justice, should reasonably compensate the successful party, should be consistent, and should remain adequate to attract competent advocates. These principles also illuminate advocate-client taxation subject to the applicable uplift and schedule. So in short, Premchand Raychard Limited is the landmark decision that gave forth to principles of taxation. In Joreth Limited versus Kigano and Associates, the dispute concerned the proper basis for instruction fees where the value was not straightforward. The Court of Appeal held that subject matter value should ordinarily be taken from the pleadings, judgment, or even settlement. If it cannot be ascertained from those sources, the taxing officer should exercise discretion based on the nature and importance of the matter, complexity, interest involved, responsibility, and work undertaken. Those are also tests for taxation, tests and principles of taxation. When the subject matter whose value cannot be ascertained, Joreth Limited case tells us that the taxing officer should now exercise discretion based on the nature and value of the matter, complexity of the matter, interest involved, responsibility, and even the work undertaken. In Kenya Airports Authority versus Otieno Ragot and Company Advocates, another landmark case, the Supreme Court considered the objective of the remuneration order and assessment of instruction fees, including disputes where a large sum was pleaded but proceedings did not mature into a judgment establishing that value. The issue was whether a pleaded figure should mechanically determine fees, and the court stressed interpretation of the relevant schedule, fair remuneration, and avoidance of arbitrary or oppressive awards. The case is particularly relevant where the 2 billion claim was struck out before adjudication. So Otieno Ragot decision tells us that you should not look at the larger sum that is being pleaded because at times there can be premature determinations before actual litigation is conducted. In Moronge and Company Advocates versus Kenya Airports Authority 2014, the court considered instruction fees arising from a claim that ended before full adjudication. The relevance lies in determining whether the pleaded value is genuinely the subject matter or whether the taxing officer must exercise discretion in light of the stage and nature of the proceedings. So the Kenya shillings 2 billion figure is evidence of the amount claimed, but it is not necessarily conclusive. The taxing officer should examine whether it represented a genuine, ascertainable subject matter under the applicable schedule or a speculative amount never tested because the claim was struck out. Disbursements must be itemized, necessary, reasonably incurred, and proved by receipts, vouchers, tickets, invoices, or other satisfactory evidence. A global Kenya shillings 5 million entry is insufficient. Research is often reflected in instruction fees rather than claimed again as unexplained disbursements unless the RO permits the particular items. Interest on cost depends on the applicable provision of the remuneration order, service or delivery of the bill, any valid agreement, and the date from which interest lawfully runs. The firm must plead and prove the legal basis and should not assume that every untaxed demand bears interest automatically. So, a challenge to taxation must follow the objection and reference procedure under the remuneration order. The dissatisfied party identifies the disputed items within the prescribed period, obtains reasons where necessary, incompetent. So have a look at the screen because we are at the end. I take a call, then I come to funge session. Hello? Hello? Nimeweza kutumia. Nilikuwa nakupigia kwa base. Yes. Nimeweka. Ndio mwingine. Page. Oh, color. Mashine huko kwa nyuma. Okay. Nice. Sawa. Good. Kisha kwa nataka mkie asiwa wangu shule mapema sana. Bai sawa. Good. Bai kwa mdeifa. Hana mwambia sahihi. Sawa. No problem. Okay, thank you. House number. Ama akiangalia plot. Good. Okay. No problem. Sawa, thank you. Nimeambiwa hizo barua zinafaa kupelekwa kesho before saa 2. Na ukifika hapo kwa bench utapigia ile namba nakupatia kwa WhatsApp. Mpigie ndio kwambie the soja mwenye atakusaidia mpaka ifikie au wazungu. Natumia namba ya soja. Basi ya soja ndio mwenye nilipea kazi ndio tutampigia hiyo asubuhi. Na kuconnect na watchman. Endelea saa 2. Sasa hiyo unaweza fika tu saa 2. Nishakutumia. Acha nikutumie tena. Na namba yake pia mara moja. Sawa. So thank you members for your indulgence. Let us read the last paragraph, then we call off the session. So a final certificate of cost that has not been set aside or altered may be converted into judgment under section 51 of the Advocates Act where the retainer is not disputed. But if the retainer itself is disputed, it must be proved. Other lawful remedies include a fee suit, enforcement of a valid section 45 agreement, ADR, and an appropriately exercised lien. So whenever there is a valid section 45 agreement, remember you are limited. You cannot tax your advocate client or party to party. Okay, advocate client, restrict to advocate client, because section 45 agreement must be signed and executed by the client in writing. So if there is one that is existing, then you cannot tax of your sums. So take note that once you have a certificate of cost, aishi hapo, you can be told by the examiner to do the proper application for entry of judgment. Okay, so the certificate of cost will be converted into judgment. And this is provided under section 51 of the Advocates Act. So today, at least milestone number 1 was to give an overview. In fact, this one bado tunai consider an introduction to our sessions, bado tujaingia into the meat details of what is expected of us. And I greatly appreciate your attendance in such activities. I remember we did a full video on all applications for probate and administration unit. We now are intending to do applications in civil litigation. Sasa hii tutaweka mpaka the actual plaints, the one that is being used in the field objection proceedings, because civil litigation is zile mashida tu ni zile, no creation of new orders, ni zile tu zenye ziko. So we are trying as much as possible kwanza to exhaust the landmark units zenye huwa watu wanaanguka. Conveyancing pia tumelala kidogo, we need to speed up, so expect more conveyancing, expect more commercial, and expect more criminal litigation. So the better we deal with the hardest in quotes units, the better itakuwa pia for us. Kumbuka pia LPM tunajaribu pia kusukuma we have trial advocacy pia, si ati tunaiacha, ni venye si tunajua trial advocacy tukipiga kutoka 2008 mpaka 2026 April, hiyo series hivyo tunaingia trial advocacy, maswali ni zile. So hapo tuko na confidence, but kuna some units very dangerous kusema kwa confidence sahi. So thank you so much for your attendance. Unless there is a comment, naona nifunge session tukimbia nyumbani. Any comment? Currently sahi niko 2023 March papers ambayo tulifanya 20, tunaenda tu hivyo before we realize tumemaliza zote. We will tick, don't worry, msore kama narukaruka, I don't have a plan. No, we will tick the papers that we have managed to do wakati tunafika milestone fulani. Tuangalie tuone hapa. Yes, Mr. Brian.
Hello, good evening to you, Victor.
Good evening.
Yes, it was a good session. I was following. Apologies, I did not participate in the first session.
No worries, bora tu umesikia hizo tests. Hiyo ni important sana. Mr. Charles Kista, any closing remarks?
I appreciate, I hope Charles Mugunda, this is my first time to attend. I'm just following, but this is an A group drill.
Thank you so much.
Okay, but I don't have anything to say. Mine is to just say thank you for the session. Yeah.
Thank you so much. Thank you, Kista pia, Mr. Charles, Mr. Brian. Thank you for your participation. Tomorrow at 4 tunapiga commercial litigation. Hivyo tukiendelea na hizo session. So thank you so much. Let me end the recording. Have a good night.